Hello and welcome to what is the first of, hopefully, an extremely intermittent series of short videos on specific housing law questions. Today the question is notice periods for Section 21 notices in England. From 26th of March to the 28th of August 2020, the statutory notice period for a Section 21 notice was 3 months. Then on 29th of August it became 6 months, when the Coronavirus Act 2020, open brackets, Residential Tenancies Protection from Eviction, close brackets, open brackets, Amendment, close brackets, open brackets, England, close brackets, Regulations 2020 came into force. This did not retrospectively amend the previous notice period, so any Section 21 notice served between 26th of March and 28th of August with a 3-month notice period is valid, at least in terms of the notice period given. Now, I've been told that some people are doubtful about whether possession proceedings, based on a 3-month notice, will be successful before a court, if heard or in front of a judge, after the 29th of August, and that 6 months' notice should have been given. I presume this is because of the wording of Section 21 Housing Act 1988, as amended on the 29th of August by the regulations, or technically by the regulations amending Schedule 29 of the Coronavirus Act, which themselves amended Housing Act 1988. So Section 21 as it stands says, as far as is relevant, effectively a court shall make a possession order for possession of the dwelling house if it is satisfied that the landlord, or in the case of joint landlords at least one of them, has given to the tenant not less than 6 months' notice in writing. So it would appear that the court must be satisfied that 6 months' notice was given to make a possession order, and that that is the case after the 29th of August. On that reading, a 3-month notice, even though valid at the time it was served, would not be enough for a court to make a possession order. It would perhaps, in the welter of changes made since March, have been helpful to have amended Section 21 to say something along the lines of the court must be satisfied that a notice of the prescribed period has been given, and then prescribe the period elsewhere. But that was not what was done. So, is this a big problem? I'm not convinced that it is. If we look at the transitional provisions, Regulation 4 of the Coronavirus Act 2020, open brackets, Residential Tenancies Protection from Eviction, close brackets, open brackets, Amendment, close brackets, open brackets, England, close brackets, Regulations 2020, and I'm not saying that again, twice is enough. This says that amendments to Schedule 29 Coronavirus Act made by the regulations do not apply to notices served before the 29th of August, when the regs came into force. And that includes Regulation 3.7, which is the relevant modification of Section 21. So, for the purposes of Section 21 notices, served up until 28th of August, the modification of Section 21 to read 6 months rather than 3 months does not have effect. Now, it may be necessary to highlight this to an overstretched district judge trying to diminish their boxwork, and it does unhelpfully leave us with effectively 2 current versions of Section 21 at the same time. But it seems to me that pre-August 29th 3-month notices remain valid, and the court cannot actually require 6 months' notice to have been given at the time of a hearing or decision, at least not for notices validly served with 3 months' notice in the period March to 28th of August. I hope that's of some use to some people, and thank you.